So we have major developments in the battle to end the NFA's suppressor restrictions. This comes after the Trump DOJ decided to shift its position, and they actually admitted that suppressors are in fact protected arms under the Second Amendment. But despite that shift, the DOJ is still defending the NFA. But now a critical case is officially in front of the Supreme Court. A petition for writ of cert was filed in front of the Supreme Court, so the Supreme Court is going to be reviewing a case called U.S. versus Peterson, and now the Trump DOJ will need to respond to this case, and a date has been set. So let's talk about what is going on in this critical case, which seeks to end the NFA's restrictions on suppressors nationwide. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply to subscribe. You can also click the like button. That just tells the algorithm that you appreciate this content, and so it shares it with more people. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to give you as much as possible for your membership. They're expanding their benefits all the time. So if you're interested in what I consider the best self-defense program out there, check them out using the link down below. And if you use my code ARMEDSCHOLAR, you can get $25 off of your sign-up fee. Now, as I mentioned in the intro, in this video, we're going to be talking about U.S. versus Peterson, which challenges the constitutionality of the NFA as it applies to suppressors. This case has now reached the Supreme Court, and it asks for the court to review the NFA's restrictions on suppressors. So for those who are unfamiliar with this case, essentially this case started back in 2022 because federal and state law enforcement officers executed warrants at Mr. Peterson's property in Louisiana. Among the items that were recovered at his home and his home-based FFL was a solvent trap that the government treated as a suppressor under the NFA. Mr. Peterson was then charged with possession of an unregistered suppressor because of that solvent trap. Now, in response to that, he moved to dismiss the charge, arguing that the NFA's suppressor registration and taxation scheme violates the Second Amendment. But on review, the district court rejected that argument. The case then went in front of the Fifth Circuit Court of Appeals, and at first, a 3-judge panel ruled in this case, and they ruled that suppressors were not protected arms at all. But then something major happened in this case. The Trump DOJ, got control of the administration, it changed over, and then they decided to change the position in this case, and they admitted that suppressors are in fact protected arms under the Second Amendment. That then forced the Fifth Circuit to withdraw its original opinion, but when the court re-reviewed this case and issued their new ruling, they still upheld the NFA, arguing that the NFA operates as a shall issue permit. So they used a different theory and they tried to twist Bruin to claim that the NFA is simply just like shall issue CCW permits. The Fifth Circuit assumed that suppressors are protected arms for the Second Amendment, but they still upheld the NFA, saying that the suppressor system works like a shall issue licensing regime. So in other words, the court treated the NFA like a permit system. Now, under that logic, because of this ruling, as long as the government processes the paperwork objectively and doesn't have discretion to deny applications, the restrictions could still be constitutional. So even though suppressors may be protected arms, the Fifth Circuit still said that the NFA survives under Bruin. That ruling created a serious controversy because if that logic stands, it could justify many types of firearms restrictions on protected arms simply by labeling them as a licensing system. And that is exactly why this case is now in front of the Supreme Court. Recently, Mr. Peterson's legal team officially filed their petition for writ of cert, asking for the Supreme Court to take this case up. The petition presents two major questions that the Supreme Court needs to address. First, can the NFA's taxation and registration system be treated like a licensing law? And second, does the NFA violate the Second Amendment as applied to suppressors? So in other words, the Supreme Court is being asked to decide whether the federal government can require registration and taxation of protected arms. Now, the petition's first major argument is that the Fifth Circuit made a fundamental mistake. It treated registration as if it were licensing, but those are two very different things. Licensing systems typically verify that someone is a law-abiding citizen before allowing them to carry or possess firearms. But registration, on the other hand, creates a database and tracks who owns firearms and what they own, so they're two different systems. The petition argues that the Fifth Circuit improperly blurred this distinction, and by doing so, it allowed the government to avoid the historical tradition test required under Bruin. Under Bruin, once the Second Amendment applies, the government must prove that a regulation is consistent with the historical firearms tradition and regulations. But the Fifth Circuit never actually performed that historical analysis. Instead, it simply presumed that the NFA was constitutional because it looked like a licensing system. And the petition argues that this directly conflicts with what the Supreme Court said in Bruin. Now, the second major argument in this petition focuses on the NFA and the tax itself. When the NFA was enacted in 1934, the tax for regulating these items like suppressors was about $200. And at the time, that was roughly equivalent to about $4,800 today. The petition argues that this tax was intentionally designed to discourage ownership. And the Supreme Court has repeatedly ruled that the government cannot tax the exercise of constitutional rights. So the petition compares this system to cases involving the First Amendment's tax on speech, poll taxes and things like that, voting taxes, and then also targeting and taxing newspapers. And so the argument in this section is very simple. If the Second Amendment is truly a fundamental right, the government cannot single it out for special taxation. Now, the petition also argues that there is no historical tradition of firearms registration in the United States. The founding generation did not require Americans to register their privately owned firearms with the government. And, they argue that if the British Crown ever tried to do this type of restriction, tax, registration, well, then the American Revolution would be probably even more significant than what it was. I mean, obviously it was significant, but to say that, the British Crown had maybe a tradition or there was a history in the US of taxing firearms and registering them, well, that simply just did not exist. Under Bruin, the government must identify historical analogs to justify modern gun regulations. But according to the petition, no such historical tradition actually exists for this type of registration and taxation scheme. The petition also warns that the Fifth Circuit's ruling has no clear limiting principle, because if the NFA can survive simply by claiming and labeling it as a licensing scheme, well, then the same logic could potentially apply to all types of items like rifles, handguns, and other protected arms. Again, in other words, the federal government, if this is allowed, could theoretically require registration and taxation of all firearms. That is why this case goes far beyond just suppressors. It raises fundamental questions about what are the limits of federal gun regulations. Now that the cert petition has been filed, this case officially enters the Supreme Court process. Right now, the Supreme Court's docket has set the government here, the Trump DOJ, to file its response by April 13th. So that is the date where the Trump DOJ will have to actually answer this petition. So that response is going to be interesting. It will potentially once again tell us what position the Trump DOJ is going to take when it comes to the Second Amendment and also suppressors and the NFA. Then the Supreme Court justices will decide whether they want to, set this for conference, if they're going to deny this, and ultimately decide what they want to do with this whole NFA question. If the court takes this case, it could become one of the most significant Second Amendment rulings that we've got since Bruin. And that is because the court would finally have to address whether the NFA itself is constitutional, and if the NFA, like the Fifth Circuit says, operates as a shall issue permit. So that's where the suppressor challenge currently stands. The Fifth Circuit upheld the NFA, calling it a shall issue permit, which they believe is allowed under Bruin. Mr. Peterson has now asked for the Supreme Court to intervene, and now we're going to wait to see, what is the Trump DOJ's response, which they have to file on April 13th. So as soon as we get more information, especially about what the Trump DOJ files and what they argue in this case, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this type of content, and so it shares it with more people. But as always, thank you so much for all of your support, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.